Let's read Articles 255, 256, 257. It doesn't say who, it doesn't identify specifically who can and who cannot propose amendment that should be done through a referendum.
There is nothing that suggests that the president is the one who was amending the Constitution. The evidence was before the court that the Constitution was being amended by what called itself a voluntary political alliance of people, which is led and coordinated by Junet Mohammed and Dennis Wawero. They went to court and they said so.
All right, those are lawyers Professor Bensi Hanya and Paul Mwangi speaking about what their dissatisfaction is. Of course, Paul Mwangi was the Joint Secretary, the BBI task force, and it forms one of the grounds of appeal by the BBI team. And let me just look for it here, that the court deliberately ignored the evidence presented to it by Honorable Dennis Oweru and Honorable Junet Mohammed that proved that they, and not President Uhuru Kenyatta, were the promoters of the popular initiative to amend the Constitution. And the question I want to ask you, Honorable Tim Wanyonyi, is can you separate the BBI, or rather the Constitution Amendment 2020, from the President?
It depends how you look at it also, because the president is the way the court held what I saw in the judgment is the president was being presented as a state officer, and in another light you see like he's being presented as a citizen, because they kept on referring to him as Mr. Uhuru Kenyatta without even mentioning that he's the president. So if he's presenting as a citizen, then it's quite okay. But if he's presented as a president, then it could be something else that can require an interpretation of the law to that extent. But as it is not. It looks like it's not him who was presenting the PBI. It is the two gentlemen, Junet Mohammed and Dennis Wawero. So the president, being the appointing authority, could be the one that was being brought in as if he's the one who initiated the process. Yeah.
What is your thinking, Dr. Pamela Odhiambo, around this? No, I'll get to you.
Thank you very much. I think several things need to be clear here. We have President Uhuru Kenyatta, who is wearing more than one hat. He is a citizen of this country. We have President Uhuru Kenyatta, who is a representative of the people that elected him. Then we also now have him, that institution of the presidency. So
when you
the process,
when you say representative, what do you mean? Because the representatives of the people, I would imagine, in the National Assembly.
Not in the National Assembly. I think President Uhuru Kenyatta is the president of Kenya for the people of Kenya, who has also been empowered by the people of Kenya to make very many decisions on behalf of the people of Kenya. That's what I mean. I think that is that simple, unless I'm not putting it right, but I think that's what I mean. Now, when we look at the whole process of the BBI, Sam, there was a part that, as the judges narrate, the start, where there was crisis, the handshake, and then the task force. And the role of the task force and all that ended at some stage. And it was their findings and gathered information that the secretariat, which was then represented by Honorable Junet and Dennis Wawero, then drafted the bill through the lawyers, and then the bill was taken now, the process of those approvals, representation to the IBCC, the collection of signatures and all that. So as at the time we are reaching here, the bill was no longer in the hands of Uhuru Kenyatta per se. I think it was now a product of the people of Kenya, and represented by Honorable Junet.
But does the genesis of that matter? Because it comes from a task force created by the president, then an implementation task force gazetted in January 2020.
Yes.
Then gives a report is converted to a bill, then a bill taken to the people in form of signature collection.
Yes. And that's why we are saying there is the Uhuru Kenyatta and even Raila Amolo Odinga, the citizen, who also have a stake in trying to propose even what is affecting our country. And that's why we are saying now when we come to the court, Sam, the issue is we are talking about the bill that is proposing an amendment. And who are the proponents? It is not Uhuru Kenyatta. And this is the evidence that the lawyers are talking about, that the judges ignored. It is Honorable Junet and Dennis Waweru on behalf of the Secretariat that are presenting the bill for the referendum.
Okay.
So we cannot ignore that and just go as if they don't exist. And in fact, together with that, when we in Kenya keep talking about Wanjiku, the question is that I really feel we should also be able to ask and clarify properly as put in the constitution or the other laws that are in Kenya. Who is this Wanjiku? Because it sounds to me, especially from that judgment, some amorphous non-existent person who does not really exist in Kenya, and we use this phrase only when we want to mobilize people emotionally to feel that there is some very vulnerable, oppressed person out there. But in the true sense, these oppressed people, are they even able to sponsor this kind of process? Those are the questions that come to the mind. And therefore, you were asking me offline what I like about this ruling. This ruling is presenting a situation in Kenya where we need to actually go back to the drawing board and clarify many issues, even in the very own constitution. Because at some stage, this applies. At another stage, this does not apply. This is what I'm seeing in our country.
Okay, Honorable Boss, go ahead.
Okay, first of all, you know, our opinion doesn't matter now, or how you feel about the judgment. You must remember the way things are presented before the court. The various parties present their case. Then what the court does, they are required within the law, in their judgment, to come up with what we call issues for determination. Here, in page 39 of the judgment, going on, I think, up to page 40, 42 or so, they have listed the issues for determination. So the court does not fish around for issues by itself. It is the issues that are presented to it by the petitioners who are before the court. In this case, you will see that this is a very solid judgment, actually. And I was editor of the Kenya Law Reports, and I've read enough judgments to know that for sure. 20 years worth of judgments. So when you read this judgment, it's solid. What the judges did is they first gave the history of the litigation. Then they went on to now look at each petition one by one. The 8 petitions. They said what the petitioners have said and what the response was. And they went on and on. And remember, when you go to the court, you don't just argue your feelings. You're required to actually argue. You're supposed to even look at treatises, scholarly works on that particular topic that actually reflect on the Commonwealth. And you will see that they quoted legal writings. They quoted authorities from all over the world, including Kenya. They relied heavily also on some Supreme Court advisory opinions. 2 particular Supreme Court, there was the advisory opinion on gender, and then there was also the Senate versus the National Assembly. They relied on that particular one. They relied on what they call the basic structure doctrine, which is a doctrine that has been adopted by the U.S., by the U.S., I think Bangladesh, Malaysia, Germany, and many other countries. This was developed in the 60s by the Indian Supreme Court. So when you go before the court, you don't just say your feelings. You actually have to take yourself to task to explain to the court what that doctrine means. And so the question that was before us was, is the question applicable in Kenya as it is applicable in other countries? Does Kenya's constitution, is it one of those constitutions that has certain eternity clauses that cannot just be amended in a pedestrian manner and has to follow a certain procedure? So,
but the question about, Honorable Boss, the question about the president's role in this popular initiative. And of course, the judges are saying that popular initiative is for private citizens, not for state officers.
Yes, because also
like
that was one of the questions that was brought before the court. And therefore, I'd like
the question I want to ask you is, because now the lawyers, Bensi Hanya and Paul Mwangi, are saying that the promoters of this bill were Honorable Junet Mohammed and one Dennis Oweru.
Yes.
At what point do you separate
I think the evidence that was brought before the court, it is very clear, and my position has always been that this was a two-man initiative that was converted into a popular initiative. And let truth be told, all Kenyans and the world watched Uhuru Kenyatta and Raila Odinga on the steps of Harambee House shaking hands. And then produced what they call a 9-point agenda without consulting Kenyans. And then, after coming up with a 9-point agenda, and this is public knowledge, so the evidence was glaring and before the court. After that, the president gazetted the BBI team, task force, and gave them certain terms of reference, again without referring to the people, if you're saying it's a popular initiative. So from inception, it did not come as a popular initiative. They tried to mutate it later to make it look like a popular initiative. Again, this is information that I'm not creating. It is in the public realm, and you people have TV footage of all this happening step by step. We have gazette notices. When my colleague here, Dr. Pamela, says that the president is the president and therefore represents us and can make crucial decisions on our behalf, that is not correct. Our constitution is very clear. You are the head of state, but you only have powers that are donated to you by the constitution. You can never do anything outside the constitution. So actually the president is not almighty powerful. It stopped. That ended with the old constitutions. Today, that is why, so the president can do only that which is allowed to do under the constitution. And that is why we have separation of powers. Okay. There are certain things the judiciary can do, which the president cannot do. There are certain things that parliament can do, which the president cannot do. There are certain things that parliament, the president can do, which parliament cannot do. So that is the very essence of the constitution. So, and this, when these arguments were made before the courts actually interrogated the constitution, looked at precedents, looked at practice over the Commonwealth, looked at scholarly works on that, because these issues have been, it's almost like surgery. I mean, lawyers have been studying them for years and years, as far back as the times of Lord Denning.
I want us to hear from the advocate here.
And just let me one last point.
I'll give another chance, Honorable Boss, I promise you. Honorable, Wakili, maybe we should be another one day. So the president told that he doesn't have that power, but then again, on 9th of March 2018, I believe was the date, the two leaders come and say that we have seen what the challenges in this country and we want to ensure that we do not go back there, because they are the political leaders and they have felt the pulse of the nation, you would assume, and they want to correct things. So what can the president do if indeed, truly he knows, he has implemented the constitution as a president and realizes there are certain gaps? What can he do if he's told that the parliamentary initiative is for parliament, popular initiative is for private citizens?
The short answer is, some of those initiatives that he can implement do not require constitutional changes. But let me just clarify something. There's a determinate finding by the High Court that the BBI process was not a popular initiative. Assuming that I was retained, because I'm a litigation lawyer, to frame grounds of appeal, I would not frame that as an arguable ground, because that would fall by the wayside. I mean, you can't frame grounds that demoralize the right-minded. There was a presidential task force, public money was expended on it, the president led all the every step of the way. He cannot approbate and reprobate his involvement on the BBI process. Once you are intimately involved, and he's falling on his own sword. You know, if you wanted a popular initiative, while staying in the background, you can achieve that quite easily. But once you gazette a task force as a presidential task force, they expend public resources. They present the report to you. It's launched in your process. You gazette the steering committee. You give them public money and all that. Look at the JLAC bill. And these are our elected leaders, and they should be telling us this, yeah? The JLAC bill, look at the JLAC bill, the procedure for initiating, the JLAC bill on the referendum bill, that is, yeah? The procedure for initiating an amendment through the popular initiative. There is no opportunity there for the promoter to benefit from state resources. There is no opportunity in that bill, as it is, the present bill, for the president to be involved anywhere. You get? I think there are many ways in which the president can be involved, but the court already clarified something. Because of his residual role at the tail end, it is better off that he stays, he delinks his involvement from the entire discussion about amending the constitution, whether by a popular initiative or parliamentary initiative. And because then he's going to have the last word, yeah? When he makes the determination that this matter needs to go to a referendum and then requires IBC, that's what the law says, to conduct a referendum. That ground sum, simply put, is a ground of appeal that will not succeed. If you are looking for areas upon which you can reverse the High Court judgment, you can look at the composition of IBC. Previously, you mentioned the question about verification of signatures. I think the issue with verification of signatures, if you permit, would have been, maybe the High Court judges would have said, in the absence of the law, can you then give us the formula that you used? Because you can't verify the signatures on an opaque procedure. At least there should have been a known formula and maybe some public input on that formula in the absence of a law. Now those ones are arguable points, but to argue that you want to prefer an appeal because the High Court erred in his holdings, in his finding that this BBI process was not a popular initiative when you think it was a popular initiative, I think quickly, that is one of the arguments that even at a preliminary level, the Court of Appeal can easily dispose of and find that this one won't succeed.
But Wakili, I have asked you that question. So maybe the president realizes after running government for as so many years as he may have, and realizes it would actually help the workings of government better if we had a prime minister or ministers coming from, just an instance, and ministers coming from parliament, and he desires that that can be put in place for better workings of government.
His desire doesn't count.
Just a moment. I mean,
institution.
Let me just raise the question. So what can he do?
The short answer is then he can use the parliamentary initiative. You know, bills, these are elected leaders, they know how bills arrive in parliament. If there's a decision that we need to reorganize our governance framework, then you create a bill through a parliamentary initiative, they will consider it the normal way, then if it touches on Article 2551, then it will be subjected to a referendum. That is the short answer to the question that you're asking.
Wouldn't it still be argued that the president has no role if the bill comes from the executive?
But what is the work of leader of majority? What is the work of the Attorney General?
It is the wish of the president and the executive.
Here's the thing, yeah? If a bill initiated through a parliamentary initiative does not require the kind of massive investment of state resources and the intimate involvement of the president in terms of popularizing that bill, because you just table a bill in parliament, MPs will consider it, it will be incubated for 90 days, that's what the law says, for public participation. If it touches on Article 2551, the president will, if approved by parliament, the president by law will require IBC to conduct a referendum. He sort of looks like a neutral umpire or a neutral arbiter in the process because he's of his reserved residual role.
Right.
But that's a different question. Only if that question is framed, then we'll determine it in that manner. But particularly what we have now, Sam, in all honesty, if you want to identify what looks like a popular initiative, it must not have state involvement, the government involvement. And that is even with the bill that is pending approval in parliament, which is being debated, expressly provides so. Parliamentary initiative also, look at, I think Mheshimiwa can tell us how they generate bills. Because when bills are introduced in parliament, you don't see the president actively involved in pushing for those bills and using public resources to advance that particular course, yeah? Although he has an interest in it. Look at the miscellaneous amendment laws that we usually put. The security amendment laws, he had an interest in it, obviously, for good governance or for whatever reason, yeah?
And Honorable Tim, looking at this, because I mean, you've been in support of the Building Bridges initiative from the start, including the products that came out of it. Did you ever foresee a situation, at that point you're determining that now the bill should take the form or should be taken through the process of popular initiative? What informed that decision that this is the better route?
You know, when it reached a stage where there's now a proposal to amend the Constitution, and the Constitution provides the two ways for amending the Constitution, either popular initiative or through Parliament. But you know now, the course it had taken, it was a popular initiative. So it had to follow that route. But now it has come and been found that from onset, there was something that was not done right, and that's why the court has held that the whole process was flawed. And you know, anything that has been done and was not done properly in the beginning, it may end up, it may be, however, you can improve it at the end. Okay. But from the beginning, if it's flawed, then it can easily bring serious questions about the validity of the process. So what we are looking at, as what the court has held, is that the process was not, and you know, the Constitution provides for citizen participation. This is the prerogative, something that cannot be wished away. That whatever decision we make, if it's going to affect the entire public, you know, the citizen might have a say. And you must take it to the people to give a say before you start processing the whole thing. But if you want to start from the other way and then you go back to the people, then the whole thing is not properly, it's not in a proper say. Yeah.
I want to raise a question with you on what can be done through the parliamentary route after listening to what the ANC party leader Musalia Mudavadi and other leaders said about this conversation.
You could also come to terms with some issues that you can fast track through a parliamentary initiative so that all is not lost, just in case the legal process takes much longer than we may be anticipating.
Yes, that's a very good proposal by Honorable Musalia Mudavadi. I endorse it. It makes a lot of sense. So that way, we will protect some of the positive recommendations that were contained that bill.
Okay, so ANC party leader is saying that some of these issues can be pursued through the parliamentary process. Yeah. Is there any chance of if the judgment of the High Court is to stand, is there any chance that anything from this process can be used at a time that that task force has already been termed to be an illegality?
Parliamentary process is an easier way to go, but it also has a lot of hurdles, because you must achieve, you realize when it comes parliamentary process, you must have the numbers to that majority. It must apply, and you must lobby both the houses to have that to that majority. If you don't achieve that, then the bill just fails at that stage. In fact, the Speaker always says that he will not even put he will not even put the question if the threshold is not there. So until you achieve that, that's the only way that you can now move the parliamentary. But that's the easier way to go. The president can use that because he can lobby behind the scenes. He can lobby members. He can use the parliamentary leadership and all that to achieve that than going through the public initiative, which is a very long route and also demanding, very much demanding than the parliamentary initiative.
But the other question is, some of these provisions, these suggestions in the bill,
yes,
if they are the products of a process that the court has said are illegal, can they still be used and taken through the parliamentary process?
I think
how would you navigate that?
I think it will come in as a fresh process altogether. They will not initiate it from where it is now, because this is already flawed. And you cannot just, if you cannot take a flawed process and now bring it up to Parliament to start. Parliament can take it up and bring it up as a parliamentary initiative instead of using the earlier process that they used, which is now before the court, and the court has made a determination on it. So if you use the same route, it will still fail.
Okay, all right.
I think the short answer is yes and no. Yes, there are some provisions that are in the bill which can be reintroduced through ordinary legislation if they seek to implement the Constitution and if they don't touch on the basic structure or what has been protected under Article 2551. For instance, we've been struggling with implementation of the two-thirds gender principle. That requires a constitutional amendment. The Duale bill collapsed. Sijenyi bill collapsed. They can reintroduce it. They tried to introduce the BBI bill. The BBI bill has collapsed. Parliament can still introduce the two-thirds gender principle through legislation. No, because they are not permitted to reintroduce matters that are required to go to the referendum through the back door. So if you seek to improve, let's say, because the court said there are 3 ways now to amend the Constitution. There's the procedure that is located outside the Constitution, and that procedure touches on the protected provisions or our core commitments, or the basic structure, if you like. If you want to alter provision under Article 2551, then the court says that is like rewriting the Constitution. You need a Constitution Review Act to start the process again, which is more like the 20 years, 30 years we have been clamoring for a new Constitution. So that one they can't introduce. There's the second, that is not the primary constituent power. Then you have the secondary constituent power, which means you introduce a bill intended to implement the Constitution. Let's say, for instance, devolution funds. If you want to increase the shareable revenue from 15% to 30%, you require public participation and a referendum. So you still need a referendum. The court said, if you want to make changes which touch on Article 2551, but seek to improve it, you don't need to now go to a procedure that is outside the Constitution. You need to undertake a process that is within the Constitution. Ask the people. We need to increase devolution funds from 15%, the shareable revenue, to 30%. Then the people will ask you during public participation, what have you done? Nothing stops you from, it's just a ceiling. It's a floor, it's a threshold. Nothing stops you from raising the figure to 30% before opening the Constitution. But if you build consensus on public participation, then you might go to a referendum so that people can approve the increase or not. So, I mean, that is just the 3-tier system. But people have to be vigilant. What I want to caution is this. I don't think the proponents of BBI should try to reintroduce it through the back door, because then Kenyans will rush back to court to protect what looks like a clandestine attempt to undermine the integrity of this judgment.
Okay. And Dr. Pamela Odhiambo, you said something that Wanjiku out here may not have the capacity to revise the Constitution or amend the Constitution, and you said that the representatives of the people would be better placed. And in that case, you meant President Kenyatta or Raila Odinga or any other person.
About that,
no, wait for the question, Dr. Pamela.
Yes.
And what I want to understand is, if you look at the articles 255, 256, 257, does it therefore, because they appear quite technical, there was an attempt by Punguza Mizigo to amend the Constitution a few years ago. That failed because they couldn't get beyond 3 county assemblies support. Now this is facing these hurdles. Is it then possible to really amend a constitution through popular initiative, in your view?
That is actually my wonder, because when you open up this constitution, the very first line reads something like, all sovereign power belongs to the people of Kenya and shall be exercised only in accordance with this constitution. The people may exercise their sovereign power either directly or through their democratically elected representatives. Now, these 2 clauses, or these 2 articles, they seem to be conflicting, because even when we are talking as parliament, that through parliamentary, we can initiate an amendment, and that is legal, that is constitutional. But we are doing it as who? As the representatives of the people, not just as Pamela, who has woken up and goes to parliament and wants to enact some amendment or raise some new bill or something like that. So that's why I'm saying, if we go the way we are going, I respect the judgment of the judges and their knowledge of the law. But then, the Wanjiku that we are talking about, you have done well to quote the Okuro's attempt. That was not a president. He's just a citizen. And he did what he did, and we saw the result. Then, the problem I have with this thing, Sam, is that all problems that may require a solution of some sort must start from somewhere. As we were at 2017, Kenya was at war. And it was this, what pushed these 2 people that we are now only reducing to 2, on behalf of the millions of Kenyans who went voting for them, to come up with the 9 points. But they didn't just come up with the 9 points and say, this is the final. They subjected those thoughts of theirs to the people of Kenya, as we are talking about. Even me, if I was to generate an idea, I am to subject it to the rest of the people of Kenya. And then, through that, they got even more than what the 9 points that they were talking about. And this is what was now condensed into the draft bill. And as a proponent, I'm aware, and it is on record, from the very beginning, I think the BBI team has always said some of these things could simply require policy issues, administrative issues. Some of the things that people talked about could require legislation. And others, like the ones we are citing, the issue of the expansion of the executive, needed to require a referendum. Now, when we are talking, for example, I may want my legal expert to tell me more about this. When we are talking about the Constitution saying at least 15%, then we have worked with this Constitution now close to 10 years. The question is, what exactly has stopped us all these years from even increasing that revenue by 1% so that it is 16? And that's why there is a need. What all the Constitution, all the legislation is supposed to respond to some idea. Now, when we are talking about Wanjiku, that's why I raised that question with a lot of honesty, because sincerely I want to understand. And I know there are many other Kenyans out there who need to understand. This Wanjiku always connotes somebody who might have not even gone to school, no job, a poor person out there, no idea. You know, that person who cannot fend for themselves.
Is that
I
so?
hope
Whose interpretation
that
is
is my understanding of it, the way we use it. Now, when Pamela raises an issue on behalf of the Wanjiku, then it is blocked from all corners. The question is, will we ever have any amendment on this Constitution? That is what Kenyans need to face. Because when a court tries, it goes nowhere. When the BBI now tries, it goes nowhere. So the question is, will we ever amend this Constitution?
But do you see a good thing in that protection to put the threshold so high so that the gains that were attained in 2010 are not washed away?
Of course, in all these things, and even the issue of the BBI, when I look at it from my perspective, I don't see any that is eroding. I don't see any proposal in it that is eroding on any of the gains that we have made before. I see an improvement. For example, the seat myself and my colleague here are occupying, it was an affirmative, a temporary seat that has a sunset clause. The one that BBI was proposing to create, yes, we were supposed to end this seat in 10 years' time.
No, wait.
Yes.
Today you don't want me to
yes.
actually.
Then
does the Constitution provide a sunset clause for the women?
For the women, yes, it does.
Which article?
It doesn't.
No, I can bring in, Madam. We even discussed this thing on one of the conferences. I can look for it and bring it, please.
If you say there's a sunset
and this
clause,
new one we are creating is actually not caveated. It is a seat that is there to stay. So I see it, to me, as an improvement.
Okay.
The inclusivity of the persons, more persons with disability, more youth, right. I see it as an improvement. The increasement, the increase of the 35%, I see an improvement.
Dr. Pam,
so the question is, who is this Wanjiku? This is what my judges and the lawyers need to tell us in this country. Who is Wanjiku?
Sam, I think you give me an opportunity. I don't think I've had a chance to speak.
I want you to respond to that. On who Wanjiku is, because you've been at the corridors of justice and you might know, but also secondly on what this judgment leaves the president with at a time that they are saying that he has actually failed the integrity test, that he has conducted himself contrary to the Constitution. What can he do now? Okay,
first, I think because the others had a chance to speak on it. First of all, when you say that we want to go back and bring it up back as a parliamentary initiative, again, you have to answer certain questions that the judges raised about what we said, the basic structure doctrine, which says which parts of, it talked about constitutional amendments. And they went into great detail and study about it. Those questions cannot be surmounted. And therefore, I almost think it's a near impossibility to bring back this same bill. Then there was the issue about public participation and whether the people were involved in making this process. So even attempting to bring it, you are actually saying on behalf of the people, we are bringing in a parliamentary initiative, taking it back to them for public participation, something that they already felt they were not consulted when it was being developed. That was developed for a certain group of people. They were serious questions, and I think, Pamela, if you read the judgment, the questions that were answered, what is a popular initiative? how should a popular initiative be initiated? How should a parliamentary initiative be initiated? That was answered. It also answered the question that should the president and public officers be used and resources used and government funding be used to push a popular initiative. That was also a question they were answering in their judgment. Yes. It also asked, one of the questions was, one of the points of determination was that was the president in contravention of Article 73? It was brought before the court, and again the court went to great pains in quoting various laws and legal writings to come up with that particular decision. Yeah, and then it also says, does the Constitution envisage a possibility of the bill amending the Constitution under a popular initiative? Does it have to have certain processes? Again, that answer was given, and they went to great pains to explain to us how it should be done. It also talked about the Constitution of Kenya Amendment Bill, that allocated, I think, constituencies and so on. Again, that was a question that was before the court. Also, another important question that was put before the court is that, has IEBC carried out mass voter registration? And is it possible for them to legitimately go to a referendum without having undertaken that? And so if you look at, and then it also said, what is the minimum voter support that is required for a popular initiative to actually be able to be said to have sailed through? So what Pamela is talking about is her personal opinion. Okay. You need to look at the judgment. Hold on. You had your chance to speak. You look at the judgment and ask yourself, when those questions were asked, the answers that the judges gave. In fact, I think the only appealable issue here, if I was the Attorney General, I would only appeal on the issue of asking for refund of the resources that were used. At least tell the court, forgive us on that one. I think that is the only thing that is at stake. But the court never said
they should refund.
No. It did. They said it was illegally used. Hold on. When any public funds are misused, then you're required. Then you'll be surcharged.
The judgment is
clear. I'm just saying when they said it contravened, there was a contravention by the use of those funds. Then, of course, what happens thereafter in executing the order is something different. But let's look at the practicalities now in response to what the ANC party leader is saying. The suggestion he's proposing may sound like a good suggestion, but it is actually completely impractical, because by the time you undertake voter registration at a minimum of 60 days, and then do verification at a minimum of 30 days, and then do voter inspection of the register for another 30 days, how many days has that gone into? It means you will not be possible to have this referendum in any case, whichever method you use to cure it, even through the parliamentary initiative. And we've not talked about the 90 days that is required for public participation if you try and bring it through the parliamentary route. So in other words, it is an impossibility, a practical impossibility, and an unconstitutional impossibility, a constitutional impossibility to be able to carry out a referendum before the next election.
There's a question I've asked you haven't answered, but I'll repeat it
just a minute to clarify something
the feedback that has been
before we move on.
I think you've explained yourself well.
Jenga Wakungu,
and then on the issue of Wanjiku, it was explained in the judgment.
Honorable boss, Kenyans are watching. Let's see what they're saying on Twitter. Jenga Wakungu, if at all, I need to see that I can't see. If at all the High Court judges relied on an already inconsistent act of Parliament, then their ruling should be reviewed, because their ruling has held up the country and we can't progress, just as Pamela Odhiambo says. I think he's talking about that notion or that position that there's an amendment that was nullified by the High Court. Jacob Abere, BBI validity ruling by High Court has opened a platform for ordinary citizens to speak and defend our young constitution from being mutilated by political war. That's a heavy word. Engineer Lazaro, you said the judges are somehow complicating this matter to fit their own judgments. They are trying to tell us that President Kenyatta has no right as a senior citizen of this nation to present his views on constitution and should be amended. I think it's a question that he's asking. And I want to combine it. I will come back to you, Honorable Boss, and Dr. Pamela Odhiambo, but let me take it to this other side, because if you look at a paragraph in the judgment that it's talking about the integrity test for the president. In taking initiatives, and this is for you, Honorable Wanyonyi, in taking initiatives to amend the constitution other than through the prescribed means in the constitution, the president failed to respect, uphold, and safeguard the Constitution, and to that extent he has fallen short of the leadership and integrity threshold set in Article 73 of the Constitution, and in particular Sabbatical 1, Subsabbatical A. And I want to read that Article 73, 1A. And authority assigned to a state officer is a public trust to be exercised in a manner that is consistent with the purposes and object of the Constitution, and a manner that demonstrates respect for the people, brings honor to the nation and dignity of the office, and promotes public confidence in the integrity of the office. I just want you to explain how the president disrespected that, and then a declaration is hereby made that the civil court proceedings can be instituted against the president or the person performing the functions of the office of the president during their tenure. How does this leave the president? Because almost portrays him and exposes him to legal processes that all along we've known he may have a bit of immunity. Yeah. Now the court says it's limited.
What I am not very clear about is whether this was one of the issues framed for the court to determine on about the integrity of the president. You know, if that is the issue, then I'm not very sure about whether that was one of the issues. It's the court on its own motion brought that
it was one of the issues.
It's one of the issues?
Yes.
Okay. If it's one of the issues, then it's a decision that also leaves room for debate, because there's a lot of, the president has got a mandate to discharge certain functions as a head of state, and as also the executive, the arm of the government, because whatever decision he takes, they are supposed to be, there are checks and balances. Parliament is supposed to approve on that, and they can also be, they can also be decided on by the courts. But the Parliament is supposed to be the one that is supposed to determine the decisions that the president makes, because he cannot just make. There are some executive orders, but there are orders that has to be go through the process of Parliament for approval before they become functional.
Yeah. All right, and Steve Ogola, maybe you could explain, because in the judgment you'll see a place where it talks about in him constituting this task force, establishing the task force, it would appear that he contravened the law when it comes to establishing public bodies. I'll get the quote directly, but on exposing the president to litigation, what then are we looking for? Are we looking at in the future of presidency in this country?
Two things. One, starting with litigation, that is not new. I think as early as 2014 or 15, the High Court, the first High Court judgment from either Bungoma or Kakamega held that the president is not immune to prosecution, to civil proceedings. You can sue him, and actually there are many cases that support that. So it's only that Kenyans were learning about this for now, the first time. Yeah? On the issue, I think on the issue whether the finding that the president breached the Constitution, I sort of tend to sympathize the president on that one, for the reason that that could raise an arguable ground of appeal, for the reason that, now this is a unique situation. Could the president have been honestly mistaken in thinking that he's advancing the Constitution when he's actually violating it? Or was he deliberately violating the Constitution knowing that to be true? In which case, it puts the Attorney General on the spotlight, on the spot to explain. But looking at, knowing that now that we know that the referendum process, the BBI process was not supported by the requisite legislative framework, you see, IBC proceeded to verify signatures without a foundational law. In between, this bill mutated from what was a parliamentary process backed by state resources into a popular initiative. In between, all lawyers, including myself, have now learned that if you want to change the basic structure, you have to rely on a process that is located outside the Constitution. I can tell you that is new learning, Sam, and I think lawyers have not just admitted it, because we do a lot of reading on comparative constitutional law and the techniques and canons of constitutional interpretation. I think very few lawyers expected that, yeah? that the High Court would find that the procedure for amending the eternity clauses or the entry provision is actually located outside the Constitution. They did that. That was. I think I like it because they have protected the gains that have been consolidated over many years. And they say if you want to reverse them, now that the judgment is there, you can actually see it makes sense. If you want to reverse them, you have to follow the same procedure that brought them in. So I think in between, unless there's a specific finding that there's a particular law the president ought to have followed and he didn't follow it, I think that's an arguable ground on appeal. But judges are entitled to make the find they did because they applied. What I like is that they applied their mind to the facts given before them, and they reached a determination or a finding that they believe is accurate. If the Court of Appeal were to arrive at a separate determination, reversing that of the High Court, I think that would also be held as binding, because at this time, personally, on the question whether the referendum, what I find dishonest is that the president decided in the boardroom, post the handshake, that we need to go to a referendum to change the Constitution, and then created a task force to work backwards. I think if that is the extent to which the judiciary approach, then they could be right. But the fact that we didn't have legislative framework and so many issues were not clarified around referendum, I would be sympathetic to the idea that he actively violated the Constitution. So that's an arguable point on appeal.
Okay.
May I just add some, just a clarification, because what forms the basic structure of the Constitution? Because it's also not defined properly, and what we look at, the provisions of the Constitution, is that all clauses in the Constitution are amendable through the process that have been provided under the Constitution, 256 and 257. And the code says the eternity clauses, the basic structure of the Constitution, and all that. So if you look at the basic structure, which part of the Constitution forms the basic structure that cannot be amended without following that certain procedures? Yeah.
Does that come out from the judgment that you have an answer to? I think the judges didn't just come up with the pronouncement of the basic structure doctrine out of the blue. Remember, there's history to it. The Supreme Court, at the beginning, during the case between the Senate and the National Assembly, and also the advisory opinion on the two-thirds gender rule, they pronounced our Constitution as a transformative charter, which means it puts it within the ambit of basically what would apply in a basic structure doctrine. Remember, we're not talking about the basic structure of our Constitution. We're talking about a doctrine that exists in the Commonwealth, that has grown from the 1960s. It looks at certain clauses in in various constitutions all over the world that are not amendable without a very specific process. So, and that is why we're saying, you don't use only because not everything can be detailed in the Constitution. But when the Constitution has a certain character and a certain description, then you fall back on precedents. And it doesn't have to be precedent from Kenya only. But in this case, the reason why we are linked to that those international precedents is because already our Supreme Court embraced and pronounced on it. Okay. And Kenya is not the only, it's not the only time that we are having these arguments and precedents being set by the Supreme Court. So if you listen to CNN today, the Roe versus Wade is being revisited by the U.S. Supreme Court. So the law is alive. It's constantly changing. Hence the reason why lawyers have work, that they keep on going to court. Okay. So there is...
Honorable Boss, we'll get to the question of basic structure of the Constitution someday, because doctrine. It appears, yes, basic structure doctrine. I was looking at it last night, and I saw a few things, but I will not say them here because it's not my role. But I look at part of the judgment saying that additionally, the BBI steering committee is unlawful because the president violated the provisions of Article 132, Subarticle 4, Article 132, Subarticle 4, Subsabarticle A of the Constitution in its establishment. So I looked at that article in the Constitution, and says that the president may perform any other executive function provided for in this Constitution or in national legislation, and except as otherwise provided for in this Constitution, may establish an office in the public service in accordance with the recommendation of the Public Service Commission. And I'm just wondering, could that be the place that he faulted in going ahead to establish a task force? Because obviously the task force is not found anywhere in the Constitution. I don't know whether it was a recommendation from the Public Service Commission. And whatever the case is, Dr. Pamela Odhiambo, do you agree with that assertion that the president may have broken the law in coming up with that task force?
Well, according to the cited clause, it may be, but I take it from a perspective that whatever the president had in mind, he wanted the involvement of the people. According to me, that's how I see it. It's not that he was just out to violate the law, because when we are talking about a people-driven initiative, I believe some, without lying to Kenyans, anyone thought that catches the attention of everybody must start from someone individual somewhere. It is very rare that something would just fall like rain from heaven and falls in every homestead, then people wake up tomorrow and say, this is what we want, and one go. Some Pamela somewhere must sit and say, there is something that needs to be done here. And so, in my thinking, and especially picking from where Lawyer Ogolla left it, that there was a crisis in the nation. And the crisis was purely because of the president himself and his colleague. And I think if Kenyans look at this thing from that perspective, then we will see a way forward.
Okay.
I think we are in this same country where there was a time when we had a coalition government, even after election during this Kofi Annan period. And we have made this phrase very popular. Extraordinary times may call for extraordinary solutions and actions. And in my thinking, given the circumstances that were in the country at the time when all this is happening, I see president who was struggling to involve as many people. And just the clarification that I wanted to make when my colleague was talking. Let us not lie to Kenyans. I think if it is a matter of public participation, this thing has enjoyed such enormous public participation right from the beginning. So let us not throw all this into the dustbin and say Kenyans have not been consulted over this thing. No, they have.
So it doesn't bother you that the task force, according to the court, was illegal, especially the implementation task force?
In the light of the clause they are citing, it may sound illegal, but from where I sit and where the beginning of all this came from, I see the president who wanted to involve the people on the whole issue of this process.
All right, Dr. Pamela, I want
and that's what has happened up to this end.
Okay, the feedback that has been coming to us, so much of it, we can only sample just a few. Basite Boit, you said that the whole process of unity dialogue shifted to rule of... What just happened? Why did the promoters of BBI lump policy issues, legislative issues, and constitutional issues all in one bill? Were they unable to synthesize and advance these things separately? That way, it would have been simpler for Wananchi to understand. That is Basite Boit. Who's a HSC? The whole process of unity dialogue shifted to rule of law. It's the judiciary business as usual when Constitution of the Republic of Kenya is concerned. DAYBREAK. Sengeli, you said the issue with anyone in government is that whenever the judiciary rules on a matter and it happens to favor them, then judiciary is deemed fair. But when they lose, then it becomes irrational and they start throwing all manner of expletives. What are expletives? I don't know what the expletives are.
I would like to say
for making time for us. Unfortunately, we don't have time. It's time for Willis Raburu. Thank you so much, Wakili Steve Ogolla, Tim Wanyonyi from Westlands, Gladys Bose from Uasin Gishu, and Dr. Pamela Odhiambo from Migori County for making time for us of this conversation. Of course, we continue to read the judgment, understand it, and know what it means for the country. Even as you continue to get involved in matters as civic in this country, it is your responsibility as a citizen to do so. My name is Sam Gituku. See you some other time. Up next is Matters or Show with Willis Raburu and his panel.